Hello and welcome to Courts Today by Live Law. I am your host Urvashi Chauhan, here to keep you informed with the latest and most important updates from the legal world. First, we will cover the top headlines, followed by an in-depth look at each update. The Supreme Court has sought Gujarat authorities' response on the contempt petition alleging illegal demolition of Dargah in Somnath. The top court has extended interim anticipatory bail of Malayalam actor Siddique in the rape case. The Supreme Court has directed examination of ex-chief of Popular Front of India at AIIMS to consider medical grounds for bail. The Supreme Court has reprimanded Puducherry Sentence Review Board for non-compliance with its previous order. The top court has expressed surprise at the Delhi High Court staying an order of discharge. The Calcutta High Court has declined to hear former RGCAR principal Sandip Ghosh's plea for bail and directed him to approach the trial court. In the liquor policy case, the Delhi High Court has issued notice on Arvind Kejriwal's plea against maintainability of Enforcement Directorate's complaint. In the matter concerning the Heera gold scam, the Supreme Court has directed Enforcement Directorate to auction 2 properties and asked Novera Sheikh to deposit 25 crores. And CJI Sanjeev Khanna has said that no oral mentioning will be done for urgent listing and requests are to be sent by email or written letters. The Supreme Court has called for response on a contempt petition filed against Gujarat authorities alleging illegal demolition of Peer Haji Mangroli Shah Dargah between September 27th and 28th without any prior notice and in violation of court's stay order on demolitions. You are aware that the Supreme Court had mandated that prior permission of the court would be necessary to bulldoze structures except those that are on public lands. The same was passed in a batch of petitions assailing authorities taking of demolition actions against houses of persons accused of crimes as a punitive measure. The present contempt petition was filed by Somnath Patni Muslim Jamaat alleging illegal demolition of Muslim religious and residential places by Gujarat authorities on September 28th, that is after the top court's stay order. Another petition also challenges a Gujarat High Court order which refused to order a status quo on the demolition of Muslim religious structures and houses in Somnath. Last month, if you recall, the state of Gujarat undertook before the Supreme Court that the lands in Gir Somnath, where demolition of structures was carried out, would remain with the government and not be allotted to any third parties till the next date of hearing. In the present case, the petitioner states that the Dargah had great religious and spiritual sentiments attached to it and was protected under the Ancient Monuments Act. However, a huge police force arrived and demolished it without giving any fair opportunity of being heard, and they kicked the Mazar Sharif of the premises and also damaged the Quran Sharif. Further, it is claimed that in order to prevent the demolition, people who were present at the Dargah lay down in front of the bulldozers, but the police force subjected them to grave physical violence. A bench of Justices B.R. Gavai and K.V. Vishwanathan heard the matter today and issued notice. It has called a response from the authorities and has listed the matter on 2nd December now. In the next update, the top court has today extended by a week the interim anticipatory bail granted to Malayalam actor Siddique in a rape case registered against him based on allegations levelled by a young actress. The hearing was adjourned till next week due to the ill health of his counsel, senior advocate Mukul Rohtagi. Following the publication of the Justice Hima Committee report regarding exploitations faced by women in Malayalam cinema, the woman actress in this case made public allegations that Siddique sexually exploited her in the year 2016 when she met him in a hotel room after he offered her opportunities in the film industry. Following public allegations, she also lodged an FIR. On 30th September, a bench of Justices Bela M. Trivedi and Satish Chandra Sharma had granted interim bail to Siddique for 2 weeks. It subjected the bail order to conditions set by the trial court and his cooperation with the investigation. During today's brief hearing, Siddique's counsel told the court that he was being asked to produce the phone and laptop used by him in the year 2016. When the bench comprising Justices Bela Trivedi and Satish Chandra Sharma asked whether the petitioner was appearing before the investigating officer, senior advocate Ranjit Kumar for the state submitted that though he was appearing, he was not cooperating with the investigation and was giving evasive responses. The court today also then questioned as to how a person could be asked to hand over the phone used in the year 2016. The Supreme Court today directed AIIMS to constitute a medical team for a thorough examination of E. Abu Bakr, who is the former chairman of band outfit Popular Front of India, to ascertain if he deserved bail on medical grounds or not. Abu Bakr has filed the special leave petition challenging the order passed by the Delhi High Court in May this year, denying him bail. He is booked for offences under IPC and UAPA. He was arrested in the year 2022 after Ministry of Home Affairs issued a notification declaring PFI a terrorist organization. His counsel, senior advocate Kamini Jaiswal, submitted that he was suffering from cancer, which was partially treated, but he was required to take a PET scan. She added that he was suffering from Parkinson's disease, dementia, diabetes, hypertension, and a part of his digestive tract had been removed. Solicitor General Tushar Mehta for the National Investigation Agency opposed the plea, saying that though the petitioner was taken to AIIMS on several occasions, the doctors never felt that there was a need for hospitalization. A bench comprising Justices M.M. Sondaresh and Arvind Kumar then directed that Abu Bakr be taken to AIIMS within a period of 2 days for examination. The court stated that he should be accompanied by police escorts. It also accepted the request made by the petitioner that his son be allowed to assist him during the examination period. The court adjourned the hearing by 2 weeks for the report of the AIIMS team. During the hearing, the bench clarified that it would consider only the medical grounds for bail and not other merits of the matter. And now let me tell you, the Supreme Court has strongly reprimanded the Sentence Review Board of the Union Territory of Puducherry for failing to consider a remission plea of a convict despite court's specific direction. The matter here relates to a plea by petitioner Karuna alias Manoharan, who sought remission after serving over 24 years of his life sentence for a murder conviction. The petitioner here was convicted alongside other co-accused. The co-accused was granted remission by the Supreme Court in January this year by overturning the board's decision to deny his premature release. Then in August, the court directed the board to reconsider Karuna's case for remission in light of the relief granted to the co-accused. Today, the court reviewed the minutes of the board's recent meeting. It found that the board had failed to evaluate Karuna's remission plea as directed, noting a lack of reference to the January order. The court remarked that the Sentence Review Board had violated the direction issued by the court. A bench of Justices Abhay S. Oak and Augustine George Massey thus ordered the Inspector General of Prisons, who is the board's member secretary, to submit an affidavit explaining the board's conduct. During the hearing, the court expressed strong displeasure, warning that it will initiate contempt proceedings against the board members, including the Home Minister, who chairs the board, for disregarding the court's orders. Further, considering the board's non-compliance and the petitioner's prolonged imprisonment, the court granted interim bail to Karuna today. The matter will now be taken up on 10th January. Stay tuned. The Supreme Court has issued notice on a plea by Sikh leader Sudarshan Singh Wazir challenging the Delhi High Court's recent order that stayed his discharge order in a murder case and directed him to surrender. Before moving to the facts of this case, let me tell you that a discharge order by a court releases an accused from further prosecution in that particular case. This type of order essentially means the charges against the accused are dropped and they are discharged from the case without going through a full trial. In this case, Sudarshan, who is the former president of Jammu and Kashmir State Gurudwara Prabandhak Board, faces allegations related to murder of former National Conference MLC Trilochan Singh Wazir in September 2021. The trial court in October 2023 had discharged Sudarshan along with co-accused Balbir Singh, Harpreet Singh Khalsa and Rajinder Chaudhary while retaining murder charges against another accused named Harmeet Singh. Earlier this month, the Delhi High Court allowed an application filed by prosecution to stay the discharge order. At the time, 3 of the discharged accused were already in judicial custody while Wazir had been released. The High Court held that Wazir's release following the discharge order had become invalid due to the stay on the discharge. He was asked to surrender, but the High Court did not bar him from seeking bail from the trial court. During the hearing before the top court, the bench of Justices Abhay S. Oak and Augustine George Massey questioned the High Court's decision to stay the discharge order issued by the trial court. Being surprised, the court remarked that staying an order of discharge was completely unheard of. The Supreme Court today issued notice, stayed the direction to surrender and also directed that the trial proceedings against Wazir would not proceed until further orders. With this, the matter will now be listed on 28th January. The Calcutta High Court has declined to hear a plea for bail moved by former principal of RGKR Medical College and Hospital, Sandip Ghosh, who has been arrested by the CBI in connection with the alleged financial irregularities at the college, as well as the rape and murder of a trainee doctor on the college campus. A single bench of Justice Tirthankar Ghosh directed Sandip Ghosh to approach the trial court to seek bail. You already know that RGKR has been in the news ever since a trainee doctor was brutally raped and murdered on campus at the end of her night duty. Nationwide protests broke out post the incident, leading to the case being handed over to the CBI and the Supreme Court taking suo motu cognizance of the same. Ghosh was initially called in for questioning by the CBI, who later arrested him on charges of financial irregularities at the hospital, followed by his alleged role in the aftermath of the rape and murder incident. Another most talked about case this year would be the Delhi liquor policy matter. Former Delhi Chief Minister and Aam Aadmi Party Supremo Arvind Kejriwal has moved the Delhi High Court challenging maintainability of the complaint filed by Enforcement Directorate in the alleged liquor policy scam case. He has challenged the trial court order passed on 17 September, which rejected his plea challenging the summons issued to him on Enforcement Directorate's complaint. Senior advocate Rebecca John, appearing for Kejriwal, submitted that when summons were issued by one ED officer of assistant director rank, complaint could not have been filed by another ED officer of the same rank. She argued that doing so is barred under Section 195 of CRPC, as this section states that the complaint has to be filed in writing by the public servant concerned or any other public servant to whom he is administratively subordinate. ED's Special Counsel Zohaib Hussain raised preliminary objection to the maintainability of the plea, saying that Kejriwal's plea is a second revision petition which has been filed under the garb of Section 482 of CRPC, which is barred in law. He also said that the grounds raised in the petition were identical to the one filed before the trial court. However, a single judge bench of Justice Manoj Kumar Ohri issued notice in the plea and sought ED's response in the matter, with the next hearing set on 19th December. The Supreme Court has granted Novera Sheikh, the managing director of Heera Gold Exim Private Limited, a 3-month extension to surrender following her failure to raise 580 crore to repay defrauded investors. Heera Gold Exim Private Limited, a company dealing in gold, collected huge deposits from the public with a promise to pay 36% dividend on the invested amount. When the company failed to pay dividends and maturity amounts, the investors across states lodged complaints alleging cheating and fraud. As a result, Novera Sheikh was arrested and the matter was investigated by the Serious Fraud Investigation Office. In January 2021, the Supreme Court granted her interim bail on the condition that she would settle the claims of the investors. But despite multiple extensions, she failed to settle the claims, leading the court to cancel her bail this year in October and ordered her to surrender. Then on 4th November this year, she filed an application seeking more time, claiming 3 properties were unencumbered and available for sale to settle the dues. The Supreme Court then directed the ED and the state of Telangana to verify the property status. After reviewing reports confirming two properties, that is Naina Towers and Heera Foodex, were free of encumbrances, the court ordered the Enforcement Directorate to auction these to raise 25 crore for the investors. During the hearing, the counsel for ED disputed the unencumbered status of some properties, but the court maintained that ED's verification was sufficient. The court has directed Sheikh to provide details of other encumbrance-free properties within 2 weeks, allowing ED to proceed with further auctions. The court reiterated its priority to ensure investors are repaid, specifying that anyone claiming interest in the auction properties must pursue rights separately through civil courts. And lastly, Chief Justice of India Sanjeev Khanna today clarified that he would not entertain oral mentioning of matters for urgent listing. The CJI said that requests for urgent listing should be made through emails or written letters stating the urgency. For those of you who do not know, oral mentioning in the court is a process where lawyers request urgent hearing for cases that require immediate attention, often outside the usual court schedule. For more details on the cases mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.